Hi everyone, I'm David Glazer, and I'm here with Catherine London.
Hello everyone.
And Bob Klepinski.
That's me.
We're here to talk about the Understanding the Sunshine Act, what physicians and hospitals need to know. Actually, I'm not here to talk about that. I'm just going to quickly introduce Catherine and Bob. So here are our quick announcements. First, next month, Ryan Johnson will be here with Catherine. Catherine's going to do a twofer on July 9th. So next month's webinar will be about telehealth issues. And so they'll be covering kind of the full range of telehealth stuff, same time on Wednesday, July 9th. I think, unless something breaking happens, on August 13th, we're going to do the most popular webinar we've ever done, the frequently asked questions. Just sort of grab bag of everything that's coming up from our clients. It was the most people we've ever had. I think it got the best evaluations. We're doing it again. So that'll be August 13th, barring changes. Only a few more things. First, sound issues. I know many people get frustrated with sound over the course of this. When you sign in over the internet, the good news is it's free. The bad news is we have no control over the speed with which the pipes choose to carry the sound. If you run into a hiccup, please use the dial-in number that Robert has. We pay for that as sort of a backup, and so it's better if you can do it for free over the lines, but don't be afraid. If you have any sound issues, use that dial-in number, and that should solve things. I'm going to introduce Catherine by saying she's a jack of all trades, and I'm going to mention something specifically that has come up 3 times for me this week. I know we have a bunch of in-house counsel on the phone, and I think in-house counsel are often frustrated with the fact that you don't necessarily have someone you can turn to say, hey, can you figure this out for me? And both Catherine and her colleague, Katie Ilton, have been used by in-house counsel around the country a great deal to do the quick project. And if you ever have something and you need a good brain on it, feel free to call Catherine or Katie directly and get them cracking on that. So that's kind of Catherine's introduction, because she's the jack of all trades. Bob Klepinski has been here for 9 very fast years. It seems like it's been less time than that, but 9 years. Before that, he spent 20 years at a device company. And Bob is an expert in all things sort of drug and device related. So dealing with the FDA, clinical trials, helping clinics and hospitals deal with device companies, helping device companies deal with clinics and hospitals, privacy, and all of that stuff. And so the two of them are going to walk us through the Sunshine Act, and Bob's going to lead us off here. So take it away, Bob.
So on the agenda today is we're going to do some background on the Sunshine Act. Some of this is manufacturer-oriented. This is not meant to be a good Sunshine seminar for manufacturers, but merely to give you the background of what manufacturers are going through so you'll understand what the effects can be on your institution as a provider. We'll talk about who must report and what kind of information is to be reported. Then one of the things that should be becoming important in the future is the dispute area. And then we're going to talk about some recommended steps for providers to take to try to clean up the database and protect their image. Now, the background of this is, remember that the government and the press generally assume that any payment to physicians is bad. It's viewed as evil corruption of one sort or another every time a manufacturer provides anything to a provider. And we have to note that the Sunshine Act did nothing to clarify what's legal or not legal. Every time we see a transfer, a payment, anything of value from a manufacturer to a provider, we have to remember we have to go through a 2-step analysis, of which this is only the second. First, we have to determine if the transfer is legal, whether it constitutes improper remuneration under the fraud and abuse laws, and that's an entry level. Second, the things we're talking about today are things that have already passed that scrutiny. We're talking about legal payments that are going to be reported under the Sunshine Act. So the goal here in Congress was not to clarify what was legal or not legal, not to improve the situation and what should be done legally, merely to expose every transfer from industry to the medical community that was illegal. The idea apparently is that if we expose every payment, we're going to reduce those in some way and save money. At least that was the attitude in, say, the states that did it, like Massachusetts. Massachusetts government, I talked to folks that genuinely believe that by costing every medical device manufacturer in the country $50,000 to $100,000, they're going to reduce the cost of medical devices. But that's just the way the people that want to put sunshine on these payments feel. we have to start with the presumption that it's inherently evil to pay you legally and figure out how to report that so the press can then look at it. So the use of this information, therefore, following on in that, I think the number one user is going to be reporters. We have some experience with this in Minnesota. Minnesota was one of the first states to put in a statute requiring reporting of payments from pharmaceutical companies to doctors. It did not cover devices, just pharmaceutical companies. The only uses that I personally know of that was for the Star Tribune here to write an annual article trying to make fun of people for the payments. And I expect that's going to be the number one use when the sunshine data is put forward. So everything we do in this is not a question of legality of the things we're doing. Everything we do is the question of how it can be twisted in a report and how it can be used to embarrass us. And it has to be a major focus. Of course, regulators are going to be looking at these things to see if anything accidentally did slip into the illegal category. Competitors may use this. It's hard always to predict depending on what kind of industry the manufacturers are in or what the provider competitors are, but some people may choose to expose large payments for competitive reasons. Patients may indeed also want to look at this and consider these payments evil. And also, this is going to matter in conflict of interest disclosures. And the strangest one, maybe it's not so strange, but we were recently told that one of the big audiences for this may be divorce lawyers. That when there's a question of assets going on, people are rather ingenious, and any physician who is separating from a spouse may find these records examined. So there's a big embarrassment factor in these records, more so than a legal exposure.
I should also mention that this information will be available to plaintiffs' lawyers, and I have to imagine that these lawyers are going to be eager to use this information to establish bad facts in any malpractice cases as well. So there are several individuals and groups that could potentially be interested in this type of information.
Now, for background, I have to confess that I'm fairly sarcastic about government bureaucracies. A lot of these things seem to involve far more expense and paperwork they can ever hope to recover in any benefit from the program, and this may be one of those. Note, please, that this is a self-funding bureaucracy. The government paperwork mill was not funded by Congress to handle all the things that are coming in and all the IT work involved. There's going to be a shortfall. So CMS is expected by us more sarcastic folks to have to fund this through enforcement activities and getting some fines. And that means that there's going to be, anytime we've seen a system set up with CMS where parties have the incentive to do things based upon financial recovery, you get more of them. So this is my worry, that we're going to see actions based on cost recovery and not necessarily on legal distinctions. Now remember that these penalties are not going to apply to you as physicians and hospitals. They're only going to be for manufacturers and the group purchasing organizations. The liability can be significant. Without knowledge, the fines can be up to $10,000 per instance and $150,000 total. Knowing failure can get you to $1 million. And I do not expect huge fines coming out of this, but because of the need for cost recovery, I can expect that the numbers can be rolled out. The number of fines can be rolled out quite high. We'll just have to wait and see what happens. But as far as physicians and hospitals, you're not going to directly be facing that. The main penalty to you is going to be embarrassment and the hope of the newspapers to humiliate you. So who has to report? Did you want to go into this part, Catherine?
Sure, I can take over here, Bob. I think one of the takeaways from the last few slides is the fact that manufacturers and group purchasing organizations have every incentive to err on the side of reporting if there's a question as to whether a transfer or payment is reportable. So in terms of who must report, there are two categories. The first category of reporting entities are applicable manufacturers. And I've included in the definition up here of manufacturers who are essentially any entity that produces, prepares, propagates, compounds, or converts a covered drug, device, biological, or supply that is not used solely by the entity for its own patients. And note that manufacturers must be located in the U.S. and can also include certain entities that are under common ownership with manufacturers and which provide assistance and support to manufacturers. So the second category is applicable group purchasing organizations, and these are any entities that purchase, arrange for, or negotiate a covered drug, device, biological, or supply for a group or individuals or entities, but not solely for the GPO itself. So I mentioned covered drugs, devices, biologicals, and supplies, and this is referring to products that are reimbursed by Medicare, Medicaid, or CHIP. And with regard to drugs, include drugs that require a prescription to be dispensed. And with regard to devices and medical supplies, to be considered a covered device or medical supply, they must require pre-market approval by or notification to the FDA.
Note that we think this tends to cover just about everything and that everybody's going to be covered by Medicare or Medicaid, but note that there are a few manufacturers we've talked to that make devices that are entirely private pay. These are usually things the patients are intensely interested in that the insurers have not moved to cover. So you may be getting clinical trials or you may be getting other consulting fees from somebody doing one of these that won't be reported. Obviously, the less reporting fee is probably the better. I just want you to note that not everything is going to be in necessarily.
Device or drug will be considered covered if payment is available under those federal programs that I mentioned. And this could include drugs or devices that are included as part of a bundled payment. So they do not have to be separately available for separate payment. So in terms of the information that must be reported, I've identified the categories here on this slide. And first, I think the biggest category is reportable payments or transfers of value, which include direct payments or transfers of value made by a manufacturer to a covered recipient. Also, indirect payments or transfers of value to a covered recipient. And then finally, direct and indirect payments or transfers of value that are provided by a manufacturer to a third party at the request of or designated by the manufacturer on behalf of a covered recipient. So I will talk about these more in depth in a few minutes, but that is the general overview of the reportable payments and transfers of value categories. And then secondly, manufacturers and GPOs are required to report ownership and investment interests that are held by physicians in the manufacturer or the GPO. So moving on to who are covered recipients. The first category includes physicians who are legally authorized to practice medicine. And a physician is legally authorized if he or she is licensed to practice in any particular state, regardless of whether the physician actually treats any Medicare or Medicaid patients or whether the physician is actively practicing at the time of the payment. So physicians include doctors of medicine and osteopathy, dentists and dental surgeons, chiropractors, optometrists, and podiatrists. Note that this definition does not include any physicians who are employees of an applicable manufacturer. And an employee is determined with regard to the IRS rules for determining an employee's status. Payments to residents, to medical residents, are also not reported. And then finally, note that physicians cannot opt out of receiving reportable payments. So in the commentary to the final rule, there was a suggestion that physicians should be able to opt out by indicating that they would not accept any payments from manufacturers. And CMS rejected this suggestion and confirmed that any physicians who fall within the definition of a physician under the rule could potentially receive reportable payments. So the second category of covered recipients includes teaching hospitals that receive payments for indirect or direct medical education or psychiatric hospital IME. CMS has indicated this could potentially include departments of universities that are affiliated with teaching hospitals in certain circumstances. But basically, the important thing to know is that CMS will update the list of teaching hospitals that appears on the CMS website, and this will be updated on an annual basis, and manufacturers will rely on this list for determining whether a hospital is considered a teaching hospital. So I'm going to move on to talk about what constitutes a payment or transfer of value under the Sunshine Act. So in the regulations, a payment or transfer of value is very broadly defined as a transfer of anything of value that's made by a manufacturer to a covered recipient and which does not fall within one of the excluded categories, which I will discuss in a minute. So small payments or transfers that are valued at less than $10 do not need to be reported unless the total annual value that's provided to any particular covered recipient exceeds $100 in the aggregate during that year. So you should note that manufacturers have the flexibility to report any payments that are valued at less than $10 but exceed $100 in the aggregate. They can either report those each specific payment or as a bundled payment, depending on how they have decided to make that report. So finally, I should note that the payments or transfers of value do not need to relate to a specific product except in certain circumstances. For instance, if a manufacturer if covered products constitute less than 10% of a manufacturer's total gross revenue, that manufacturer is only required to report payments that relate to a specific product. So there are some special rules for reporting CME and food and beverages, which I will talk about in a moment. And also payments relating to research are reported differently than other payments, and these payments, reporting of these payments can be postponed for up to 4 years. But the bottom line to take away here is that you should assume that anything you receive from a manufacturer will be reported unless an exclusion clearly applies.
And the difficult and embarrassing thing for us lawyers is that most of the arguing is going to be about trivial stuff. The big payments, like for a major clinical trial, are always going to be clear. All the questions are going to be, what if I went to the CME but I didn't eat the breakfast? What if we got bagels for the in-service and some of the bagels were eaten by a doctor who picked one up on the way by? These trivial questions are going to consume a lot of your time and sort of expose some of the difficulty of this. And I think the fringe issues will often be more interesting than the basic ones.
So hopefully we will try to answer as many of those questions up front here as possible. But I will move on to talking about what payments or transfers of value should not appear in the publicly reported information. It's important to know what these are so that you can dispute any payments or transfers you see that fall within one of these categories. So, as I mentioned, I will talk about more in a minute. Certified and accredited CME is included as an excluded payment or transfer of value that is not reported. In addition, buffets, meals, or foods and beverages that's available generally to participants at a large-scale conference or event is not reported. CMS has clarified that in these instances it's generally difficult to establish the ideas of the people eating the food and has not imposed an obligation on reporting entities to report these types of meals. In addition, product samples that are intended for patient use and not intended to be sold, as well as educational materials that directly benefit patients or that are intended for patient use, are also excluded. Now, note that these educational materials or product samples must be intended for patient use. And CMS has stated that items such as journal reprints and textbooks that are provided to a physician or other covered recipient do not fall within this exclusion, even though they might have some indirect benefit to patients. CMS does not consider these to be items that directly benefit patients or that are intended for patient use. I know the AMA is lobbying hard for journal reprints and textbooks to be included within this exclusion, so that has been a topic of much discussion as of recently.
Yeah, and this is an area where if you're not accepting any other payments, you may not realize that journal reprints being mailed in are suddenly going to be totaled up. And if you get over $100, your institution may be reported for taking payments from some manufacturer when you had never dreamed it was happening.
Absolutely. Note that a loan of a medical device for a trial period not to exceed 90 days over the course of the reporting year are also excluded, as well as items or services provided under contractual warranty. Any transfer made to a physician when the physician is not acting in his or her professional capacity is excluded. For instance, if the physician is acting as a patient, that would not be reportable. In addition, discounts or in-kind items used for the provision of charity care are also excluded, as well as dividends or profit distributions from or ownership or investment interests in a publicly traded company. And then health care that's provided to employees under a self-insured plan. So for instance, if a manufacturer provides health care coverage to physician employees under their manufacturer's self-insured program, that would not be reportable. And then finally, payments or transfers to a physician either solely for non-medical professional services or with respect to a civil or criminal action are excluded.
We had a question that came in about what constitutes a large-scale conference, and if a company puts on a training program or an educational program with, say, 30 people and provides a meal, is that in that exemption? And our interpretation is no. If you have a company event where you have invitations and you know who's there, you're going to be reporting. It's only if you have one of these large-scale walk-up things where you can't really track people, such as if a company has popcorn at its booth at a medical conference and people take a handful as they come by, you're not going to have a sign-in for the handful of popcorn. But if you have, if your physicians go to a grand rounds type talk with a controlled number of people that the manufacturer is sponsoring, putting on food, that's going to be reportable. So if you don't want to be reported in those, you're going to have to make it clear that you're not eating in those situations.
That's exactly right. CMS has stated that what they really care about is whether or not the manufacturer could potentially identify the individuals who are participating. So if it's a smaller conference, the chances that the recipients could be identified is increased. So that moves into our food and beverage slide. And in meals and group settings other than such conferences or large-scale settings, manufacturers are required to report the per-person cost of food or beverages for each covered recipient who actually partakes in the meals. So I have an example. I'll move on to the next slide to show an example of this, but note that, say a sales rep brings a lunch costing $165 to a 10-physician group practice. If 6 of the 10 physicians and 5 of the support staff eat the meal, the cost of the meal is $15 per participant, given there are 11 participants who actually ate the meal. And the meal would need to be reported for the 6 physicians who participated, but not the 4 physicians who did not participate. Also note that if, say, the value was $100, this would fall below the threshold, the $10 threshold for reporting, and would not need to be reported.
Remember that this threshold sounds like a gift from the government, but the $100 limit is not that high, so the companies are going to have to track all these $5 and $8 events just to make sure they don't get over the 100. We had a supplementary question coming in about drug reps bringing lunches.
Hopefully we just answered that question.
Well, I do want to make a distinction between what the lunches are brought for. Under the Pharma Code and the AdMed Code, companies are, the consensus is that you can bring lunches when there's business going on. So if you're bringing lunches in for an in-service training, for example, that's viewed as perfectly acceptable and legal. If you're bringing lunches in for a direct sales conference with a doctor talking about a drug or device, that's perfectly acceptable. The old practice of bringing lunches around as a general gift and leaving them out, I think, is gone. I think the days of the free lunch, so to speak, are over.
So I think the important takeaway here is that because meals are not attributed to physicians who don't attend or actually participate in the meal, you should be very clear if you do not want to receive the meal or partake in the meal, and then the meal should not be reported based on the example that I just demonstrated. So, CME, the important thing to remember here is that any payments made by manufacturers to physicians for speaking at a CME would not be reported if the following criteria are met. First, the CME must be accredited or certified by one of the bodies specified by CMS. The manufacturer cannot pay the covered recipient directly, so the payment has to go to the CME entity, and then that entity makes the payment to the physician. And then finally, the manufacturer cannot select the speaker, cannot have any say over the physician speaker who is ultimately selected.
We had a question on whether this applies to nurse practitioners. Catherine, nurse practitioners were not included in the original list of covered people, right?
That's correct. So for purposes of the Federal Sunshine Act, nurse practitioners are not included, so any payments or transfers of value would not be reported under the Federal Act. Now note that Massachusetts and Vermont have individual state reporting requirements, and these states have more robust reporting requirements, and I think either or both of those states could possibly pull in non-physician practitioners as well into those reporting requirements.
And remember, this does not address the legality of such payments. A lunch provided to a non-physician nurse practitioner could still be viewed as remuneration, which is a violation of the fraud and abuse law. So when it comes to the salespersons bringing in the free lunch to the nurses, it's not really a reporting thing as to whether it's under the illegal analysis that we discussed at the beginning. So it could be wrong under the fraud and abuse law, and if it happened, would not be reportable under Sunshine.
Okay, so we received another question here, which I think we will touch on in a moment, but the question is, if a clinic is provider-based to a teaching hospital, is the payment associated with a catered lunch brought to the clinic reported to the teaching hospital or to the providers who actually received the lunch? So this gets into this next slide here regarding indirect payments or transfers of value, and hopefully we will address this question here in, I think, the next slide. But it's really, really tricky when we get into the indirect payment or transfers of value context, because I know most of the questions we receive somehow pertain to this indirect payment principle. So under the federal rules, an indirect payment or transfer of value is defined as any payment or transfer of value made by a manufacturer or GPO to a covered recipient or a physician owner or investor of the GPO that is made through a third party where the manufacturer or GPO either requires, instructs, directs, or otherwise causes the third party to provide the payment or transfer in whole or in part to a covered recipient. Now, this has generated a lot of questions and a lot of discussion, and I will hopefully provide some clarification with some examples here in a moment, but it's important to note that indirect payments or transfers are not reportable when the manufacturer does not know the covered recipient's identity. So if the manufacturer knows, either has actual knowledge of the identity of the covered recipient who ultimately receives the payment, or if they act in reckless disregard or deliberate ignorance of the recipient's identity, then this would be considered an indirect payment or transfer of value. But this is not intended to reflect situations where a manufacturer makes a payment to an entity and that entity down the line incidentally happens to provide the payment to a physician-covered recipient. If the manufacturer has no reason to know that the payment will ultimately be made to a covered recipient, those payments would not need to be reported.
So in this clinic question, if the clinic is listed as the Sister of Mercy Hospital Clinic, and it's attached to Sister of Mercy's teaching hospital, I mean, it's going to be obvious to the manufacturer, and that would probably put the curse of knowledge upon them and have them report it.
Right, and that's an instance in which we have one payment. You know, CMS has provided some examples of instances where payment that's made to one covered recipient and also ultimately passed on to another covered recipient. In those cases, the payment's reported in the name of the covered recipient that ultimately receives the payment. So if a physician at a teaching hospital eats a lunch that's provided by the manufacturer, and the manufacturer has reason to know that that particular physician ultimately was receiving that lunch, that would be reported in the name of the physician and not the teaching hospital. So moving, that gets to, this sort of touches on the first example I have here, but I think hopefully these examples should provide some useful context to all of the principles we just described. So in the first case, if a manufacturer provides payment to a teaching hospital which is intended for the physician employee, as I just mentioned, this payment would be reported in the name of the physician employee who ultimately received the payment. Now, what if the employee is not a physician? In that case, we have a payment that's made to a non-physician, non-covered recipient employee of a teaching hospital. In that case, the question becomes, well, is the payment made to the employee either at the request of or designated by the manufacturer on behalf of the teaching hospital? If it is, that's a reportable payment. If not, that there's no reportable payment because there's no payment to a covered recipient. Next question is, or next example is when a manufacturer makes a donation to a physician professional organization. Here the question is whether the manufacturer made the payment to the organization for the organization to use at its discretion, or whether this payment was potentially earmarked for funding to physicians. If the latter is the case and the manufacturer intends this payment to be made to physicians, then that would be a reportable payment. But if it's just a general donation for the organization to use at its discretion, then that would not need to be reported. So I think we've already touched on the CME example. But now what about, here we're back in the textbook context, what about if a manufacturer donates a set of dermatology textbooks to a group practice? So in the group practice context, payments made to a group practice are attributed to each physician-covered recipient who either requested or on whose behalf the payment is made or who are intended to benefit from the payment. So it's not the case that every payment to a group practice should be reported in the name of each of the physician owners of the group practice. In this example, for instance, if it's a group practice and there are some physicians in the practice who are dermatologists, I think it's fair to assume that the manufacturer would report this payment in the name of all of the dermatologists at the practice, but probably not in the names of the other physicians who also practice there. We've talked about journal reprints, and I should mention that the value of a journal reprint is calculated based on the cost the manufacturer paid to acquire the actual reprint. But I think it's interesting to know that the AMA, I think in the past day or two, has actually issued a position that they're going to be lobbying hard for journal reprints and textbooks to be included within that exclusion that I discussed earlier. So there might be there's going to be a lot more discussion of the journal reprint issue in the coming months.
Does CMS have the authority to make these decisions without a rule change?
So the journal reprint, that comes from the commentary and the guidance that has been issued by CMS. I don't believe there was any mention of journal reprint specifically within the regulations. So CMS could potentially issue guidance reinterpreting the scope of the exclusion. So moving on to other examples, what if a manufacturer pays a consulting firm for services and the firm employs a physician on the project? Well, if the firm incidentally employs a physician and, again, the manufacturer did not have knowledge, then that would not be considered an indirect payment or transfer. However, if the manufacturer intended the payment to be made for the services of a physician, that could be considered a reportable payment. So the last example I have here is if a physician says to a manufacturer, oh no, don't make a payment to me, instead donate the payment that you would have made to a charity. In this case, this is a payment at the request of a covered recipient, and this payment would be reported in the name of the physician. And when the payment is reported, it would also have to be noted in the report who ultimately received the payment. So, moving on to what information is actually going to appear in the public database. So the database will display the covered recipient's name and address, NPI and specialty, state license number, as well as the amount and date of the payment or transfer. And you should note that manufacturers have some flexibility to determine the amount assigned to any particular payment or transfer, as well as the date of certain payments or transfers. So it's important to understand that there might not be consistency among manufacturers in how they will report these items.
It's a picky little item, but some physicians do not want their home address blasted over the national news, so you may want to have your physicians use the office address for any payments.
Mm-hmm. It's a good point. And manufacturers are required to report what form the payment or transfer value was made in, as well as the category, the nature of the payment or transfer value, which I will touch on more in a second. If the payment was related to a particular covered product, that is also identified in the reports. And then I mentioned certain payments are subject to delayed publication. Those would need to be flagged in the report. And then, as I just mentioned in the previous slide, if the payment is made to an entity or individual at the request of or designated on behalf of a physician, the name of the individual or entity who ultimately received the payment will appear in these reports. So, finally, if the payment's made to a physician who has an ownership or investment interest in the manufacturer, that will be flagged in the reports. And then manufacturers can also add additional information or context if they decide to do so, but they are not required to add that information. I won't go in depth here, but manufacturers have to categorize any payment or transfer into one of these defined categories. And note that there is no other category here. They have to fit them into whatever category best describes the type of payment. So I will mention that there are special rules for reporting research payments. And these research payments are those payments that are made in connection with research and subject to a written agreement and or protocol. So research is defined as a systematic investigation to develop or contribute to generalized knowledge about public health, including behavioral and social sciences research. So this is a pretty general definition of research. And as I mentioned, certain research payments are eligible for delayed publication if the following criteria are met. So in general, research in connection with development of a new drug, biological device, or medical supply, or a new application of a drug, biological device, or medical supply are potentially eligible for this delayed publication, which means that the payment won't be reported until either FDA approval or 4 years after the date of the payment. So I've included on the slide what information is reported about these research payments, and I think it's worth mentioning that the principal investigators must be included in this report, but CMS has declined to require manufacturers to report sub-investigators, but only principal investigators. And I believe they can report up to 5 principal investigators per report. So I will move on to talking a little bit about the types of ownership and investment interests that are required to be reported under the Sunshine Act. So in general, manufacturers and GPOs have to report any ownership or investment interests held by physicians, even physician employees, there's no exception here, and the physician's immediate family members. And I've included on this slide who is considered an immediate family member for purposes of this reporting requirement. So manufacturers and GPOs have to report the dollar amount invested, the value of the investment interest, and also the terms of ownership or the investment interest.
Could I interject briefly to clarify that the family members are listed in this ownership area but are not listed in the payment area? However, there's a question of what constitutes an indirect payment, so there's open questions as to whether any payments to family members could end up being considered indirect under that. But the only place a family is directly mentioned in the statute and regs is in this ownership area.
Important to note there. So ownership or investment interest includes the following items which I have listed on this slide. And the ownership or investment interest may be direct, indirect, or through debt, equity, or other means. I don't think there's anything particularly notable here, but I will mention also some of the exclusions to an ownership or investment interest. On this slide, I've identified what is not included in the definition of an ownership or investment interest. And one question that we've received recently is that an ownership or investment interest doesn't need to be reported if the manufacturer or GPO is not aware that such interest is held by a physician. And you'll see here that those types of ownership or investment interests are specifically excluded from reporting. We will move on now to talk about what physicians and hospitals can actually do to ensure the accuracy of data that is reported on through the Sunshine Act. And now this is referred to by CMS as the Open Payments System. So if you hear open payments, you should know that that is the new term used by CMS for the database that will report all of these payments and transfers of value. Registered physicians and teaching hospitals are able to review and dispute any data that's submitted about them before it is released to the public. It is really important to know that CMS is not intending to notify any covered recipients if there is information that is going to be reported about them. And in addition, manufacturers and GPOs are not required to notify covered recipients if they are reporting payments about the physician or hospital. Even though CMS has recommended that manufacturers and GPOs provide covered recipients with an opportunity to review data prior to submission, CMS expressly declined to require this type of notification.
And this is going to cause some tension between providers and manufacturers, in that I've had some providers request pre-review of submissions, and manufacturers are loath to do that because of the huge bureaucratic crush of getting all this information in and tracking it. So it's not going to be very practical for manufacturers to offer pre-review. So I expect there to be some back and forth between payers and payees on this issue.
Starting in July of this year, physicians and hospitals will have 60 days to review and dispute data that has been reported by manufacturers and GPOs to CMS. So physicians and hospitals are required, manufacturers and GPOs are required to work with physicians and hospitals in order to correct any disputed data. Note that CMS has expressly stated that it does not intend to help mediate or oversee these disputes, but expects the manufacturers and covered recipients to work collectively and collaboratively among themselves to resolve these disputes. So disputes that are initiated within the first 45 days of this 60-day review period, which are not resolved by the end of the 60 days, will be shown in the publicly reported data as under dispute. So these will be flagged, but they will still be up there. Note that any disputes that are initiated after these 45 days may not be identified as disputed in the publicly displayed data. CMS has stated that the review and resolution system will be open year-round, so physicians and teaching hospitals can certainly review the information that's made available about them and try to initiate disputes with manufacturers. But these, the disputes that are initiated and resolved during this 60-day review period are the only, essentially the only chance for manufacturers to correct this information. CMS has stated that it intends to update data from current and previous years at least once annually based on resolved disputes. And physicians and hospitals will have 2 years to dispute any reports after the data is made public. So in order to review and dispute information, physicians and hospitals will need to register in the Open Payments database. And registration is required before you can even have access to the information. So this year, registration is conducted in 2 phases, with the first beginning in June, this month, at which time physicians and teaching hospitals can register in the Enterprise Identity Management System and request access to the Open Payment System. And then beginning in July, you can register in the Open Payment System and begin to review, dispute, and correct information. So I have included a timeline here which identifies exactly when all of these steps will be occurring. And you can see that in July is the review, dispute, and corrections period, which will extend until September, when the data will be made publicly available on the CMS website. We have included on this slide some recommended steps. So what should you be doing at this point and moving forward in order to protect yourself and ensure that the reported information is in fact accurate? The first item I have here is to verify that information in the NPI database is current. This database will be used by the industry to confirm that they have identified physician-covered recipients accurately. Secondly, we've mentioned this already during this presentation, but it's very important to make very clear with industry when you are declining a payment or transfer of value. We mentioned this in the food and beverage context, but this is clear in every context. If you do not wish to accept a payment or transfer, make that very clear. And also, remember that if you decline a payment but still direct that the manufacturer make the payment to another individual or entity, those payments are still reportable. Again, Bob just touched on this, but ask industry contacts to provide information to you before it is submitted to the government. Again, manufacturers are not obligated to provide this information to you, but you have every right to ask. This last bullet point here I have included is request to see the assumptions documents. And what this is referring to is manufacturers have the option to submit an assumptions document to CMS, which identifies the methodologies they used to calculate transfers of value and the assumptions they made when deciding whether transfers and payments were reported. And if there is any question over why a payment was made or reported, ask the manufacturer if you can see their assumptions document to try and have a better understanding of how they calculated a particular value or why they included that payment in the reportable data.
At this time, I do not expect many manufacturers to submit assumptions documents, so we'll just see how this shakes out.
Absolutely. You also have the option to ask manufacturers to add a context description when reporting payments or transfers of value. As I mentioned before, this category or this context description is not required. Manufacturers do not have to add that to the data, but if it could provide useful clarification as to why a payment or transfer was made. Also, as Bob mentioned earlier, entities that require conflict of interest disclosures may use the public database to identify whether physicians have made all of their conflict of interest disclosures. So ensure that all conflict disclosures are in fact current, and keep those current and come back to those on a regular basis. So let's see. We have one question here. How do we register? What web page? Do you have the links? I have provided the links in the end of this. At the final page of the slide, I will talk more about how the final slide in this presentation, I will talk more about how you can actually register and the steps that you need to take at this time in order to complete the registration process. So I will keep finishing up the recommended steps here. CMS has actually released an open payments mobile app for physicians and industry. In this app, I cannot vouch for this myself because I have not used this app, so that's why I believe I have included a question mark on the slide. But this is a free app that's intended to track payments and can be used to share information between physicians and manufacturers. Note that this app does not interact with any CMS systems and cannot be used to directly report data to CMS, but it's just one option for physicians and industry to try and keep track of payments during the course of a reporting year. Also, just generally for hospitals, consider Sunshine Act issues when deciding to start taking GME payments. Remember that if you are becoming a teaching hospital by accepting these payments and have not previously, you are entering into Sunshine Act territory, and payments made to the hospital will now be reported. So register now and be prepared to review data in July and August. And as I mentioned, the CMS website has all of the registration information available, and I have included a link to that website at the end of this presentation. And CMS is posting on a daily basis updated information for how the specific steps physicians and hospitals can take to register. And also note that I believe there is a webinar or presentation that will be put on by CMS tomorrow, which provides the most updated information for physicians and teaching hospitals and identifies the specific steps to take to register. So that is, I believe it's tomorrow during the day, but that information is available on the CMS website. Oops. Finally, know the key dates. So June 1st, registration is now open, and you can request access to the open payment system. Beginning in July and August, be ready to register in open payments and review, dispute, and work with manufacturers to correct information. And then finally, September 30th is the date that CMS will release data on the public website. And each year thereafter, this data will be made available on June 30th. So as I mentioned, the CMS Open Payments website, this is basically the first step that you need to take is to go to this website and start taking the steps to register to have access to the Open Payments system. And then also the AMA has a really helpful, I think, toolkit for the Sunshine Act available on its website, and this is sort of a really great go-to place for updates on the Sunshine Act and what's happening for physicians and teaching hospitals.
We had one question come in that I don't know the answer to, Catherine, is whether physicians have to register themselves or whether you can just have some central administrator for a practice register them all.
That's a great question, and actually I don't know specifically whether physicians can delegate that type of registration. They might have to register themselves and then allow, manufacturers can delegate the database entry and registration to other individuals who are affiliated with the manufacturer. And there might be something similar for physicians, but I do not know offhand. I think CMS is releasing information about this daily so that I can certainly follow up on this question, and I will try to find the answer and get back to the requester on this. Okay. I think we are done with our questions for now.
I want to thank everybody for joining in.
If you have any follow-up questions, I realize we covered a lot of ground here, and there might be a lot of different scenarios that you have questions about whether a particular payment may be reported. And if you have, once you have access to the Open Payments database and are considering trying to dispute any reports that are made, please let us know if you would like us to assist.
Yeah, we're eagerly looking forward to all those questions on the worth of a bagel. There's an extensive section in the preamble to the publication of the regulation discussing how to account for bagels. So Catherine is really an expert on donuts and things of that nature now.
I will be ready for all of your bagel-related questions.